Right, thank you. This is a motion court, 26 May 2020. We'll begin the roll with a judgment. It is in the matter of Clark versus Clark and others. It's a judgment prepared by me, and I will simply read the final paragraph. In the result, the following order will issue. 1, the applicant's application to join the Graham Clark Electrical Trust, IT 296/99, in the divorce action is dismissed with costs. 2, the applicant's Rule 30 application is dismissed with costs. 3, the applicant is ordered to pay the costs of the respondent's application to strike out. I hand down the judgment. A PDF version of the judgment will be emailed to the parties following this hearing.
Matter number 1 on the roll, 3544/2015, Claassen versus Claassen.
Yes, matter of Claassen versus Claassen. Who's hearing in the matter?
Ellis, my lord.
Thank you.
I'm appearing on behalf of the plaintiff in this unopposed divorce action. The defendant having withdrew her defense and a counterclaim herein. There was an affidavit filed in terms of the directives. My lord would have noticed that the parties have lived apart since 2015, and the submission is made that the marriage has broken down irretrievably. The original marriage certificate was filed as Exhibit A and the original deed of settlement as Exhibit B. I submit that the proper case is made out. If my lord is so satisfied, I will then move for an order in terms of the draft order.
Yes, thank you, Ms. Ellis. I am satisfied, and there will be an order in terms of the draft final order of divorce, which is filed in the court file.
As it pleases, my lord.
Matter number 2 on the roll, Ndama versus Ndama.
May it please you, my lord, I also appear in this unopposed divorce action in which the parties reached settlement prior to the institution of action.
Yes.
My lord, might I move for one formal amendment? My lord would have noticed on the face of the summons, the plaintiff's surname is spelled incorrectly. It should be Ndaba with B instead of the Ndama. Might I move for that amendment?
Yes. Yes, the plaintiff's signature, surname on the face of the summons will be amended to read Ndaba.
As court pleases, my lord. My lord would have also noticed there was an affidavit filed in terms of the directives
Yes.
in which the allegation is made that the marriage has broken down irretrievably. There is also a further affidavit filed herein by the plaintiffs explaining why the original marriage certificate cannot be produced and a copy is annexed thereto. The original consent paper is filed and it is marked as Exhibit A. I submit that the proper case is made out in this matter, and if your lordship is so satisfied, I'll move for an order in terms of the draft order.
Yes, thank you, Ms. Ellis. I am satisfied. There will be a final order in terms of the draft of that order in the court file.
As court pleases, my lord.
Matter number 3 on the roll, Terblanche versus Terblanche.
This is a similar action, my lord, where I appear on behalf of the plaintiff. It's also an action for an unopposed divorce. It is a deed of settlement. The original is before you, as well as an affidavit filed by the plaintiff in which she confirms that the marriage has irretrievably broken down. The family advocate had, in their endorsement, referred the court to the temporary living arrangements of the children, that pending the mother securing suitable accommodation for herself, who is going to be the primary caregiver, that the children would remain with the father temporarily. The plaintiff has addressed this in her affidavit, and the original marriage certificate and original deed of settlement do appear in your papers. If satisfied, I would move for a decree of divorce in terms of the deed of settlement.
Yes, thank you. I am satisfied. There will be a decree of divorce and an order incorporating the terms of the deed of settlement.
Thank you.
Matter number 4 on the roll, Thompson versus Thompson.
Your Lordship, it's Anthony Bose.
Thank you,
I
Mr.
appear
Bose.
I appear on behalf of the plaintiff in this matter. It's a similar matter, Your Worship, an undefended divorce. The defendant has filed, he's provided his consent to the
Yes.
divorce, and all that he sought, Your Lordship, is a decree of divorce. The relevant affidavit has been filed together with the original marriage certificate, and there's no order as to costs in this matter.
Yes, thank you, Mr.
Yes,
Bose.
Your Worship.
I am satisfied. In this matter, then there will be a decree of divorce.
As the court pleases, Your Lordship.
Matter number 5 on the roll, Grace versus Grace and another.
My Lord, I appear on behalf of the applicants in this matter.
Thank you.
My
Mr.
Lord, by agreement between parties, may the matter be postponed to the 18th of June, with the rule to be extended and costs in the cause.
Yes, thank you, Ms. Morgan. By agreement between the parties, this matter is postponed to the 18th of June 2020. The rule is extended accordingly and costs will be in the courts.
As the court pleases.
Matter number 6 on the roll, Double Four Properties Pty Limited.
May it please you, my Lord, I appear on behalf of the applicant in this matter. This is an application for the removal of certain restrictions on the title deed.
Yes.
Your Lordship would have noted that an interim order was granted prior to lockdown. There have been a number of extensions of the rule needs compliance, my Lord, and I submit that a final order can issue. If my Lord is satisfied, I would seek such a final order.
Yes, thank you, Ms. Bands. I am satisfied, and in this matter, the rule is confirmed. A final order will issue.
As the court pleases, my Lord.
Matter number 6A on the roll, De Jong versus De Jong.
Yes, is there an...
On behalf of these persons one.
Thank you, Mr. Bands.
Mr. Palmer appears on behalf of the applicant. I believe he's in the lobby somewhere. My Lord, we are attempting to settle the matter, and we are preparing a draft. Might this matter stand down and the draft order emailed to your clerk?
Yes. Well, provided that if the matter is settled, then I will be in a position to make that order on the basis of a settlement. Otherwise, it's not a matter that I would be in a position to hear.
Yes,
but I beg your pardon?
The interim arrangement that is being set up pending the finalization of the matter, we still haven't got an advocate report, for example. So,
indeed. Yes.
And
right. Well, the matter will then stand down, and you can mention at the end of the roll as to when you may be in a position to for the matter to be finalized before me. Matter will stand down.
Matter number 7 on the roll, First Rand Bank Limited versus Boyana and another.
As it pleases the court, my Lord, I appear for the applicant in this application in terms of Uniform Rule 46, capital A. My Lord, this matter was before you on its previous hearing in the motion court of the 21st of April. At that stage, the directive was that applications of this nature were not going to be heard, and that any relief sought in accordance with would be required to be postponed. As a result of that order, the matter was then postponed to today's date. From my understanding of the directives that were issued, which came into effect of the 18th of May, the applications of this nature are no longer excluded. May I inquire if my Lord would be inclined to grant relief, or are these matters still to be?
Yes. No, I would be inclined to deal with the matter. I don't believe that that these matters are excluded from hearing. The essential question regarding the equities of dealing with matters of this nature arise in relation to potential eviction proceedings, given the circumstances we currently find ourselves in. But I would be inclined to deal with these matters, and I don't believe that the directive excludes their finalization.
As it pleases the court, my lord, then the position is such that this property is not the primary residence of the debtor in this instance. That's clear at paragraph 10.6.10 of the papers, if one has regard to the service of the matter and where the party resides. In the circumstances, my lord, the position having been in this court that if it is not the primary residence, the need to set a reserve price regarded in the matter is then set, ordered subject to execution without a reserve price. I would then be inclined to move for an order, my lord, of such terms that would reflect orders of prayers 1, 2, 3, 4.1, and 6 of the notice of motion.
Yes, 1, 2, 3, and 4.1.
That's correct,
And
my lord,
6.
as well as 6 being...
Yes. Yes, thank you, Mr. White. In this matter, there will be an order in terms of prayers 1, 2, 3, 4.1, and 6 of the notice of motion.
As the court pleases, my lord.
Matter number 8 on the roll, Netbank Limited versus Arthur and another.
Please, my lord, I appear on behalf of the applicant in this application.
Thank you, Mr. Ramsey.
This is a Rule 46A application, similar to the last, my lord. My lord would have noted from the papers that there has not been personal service on the first respondent, who is indeed the judgment debtor. This matter was previously before this court on the 17th of March, due to a lack of service on the second respondent. However, there's still not been service on the first respondent.
Yes.
My instructions, my lord, are to request that the manner of service be condoned by this court, consideration of circumstances, particularly in light of Rule 46A(3)(d). However, if your lordship is not inclined to permit the manner of, or to permit the service as it stands, I would request that your lordship consider permitting service upon the work address of the first defendant, which is where the nulla bonus return of service originated and where that writ was served. The issue that we have here is that the date for the application, as per the papers, is 17 March and has subsequently been superseded by the events in the pandemic of the coronavirus. And in those circumstances, I'm in your lordship's hands.
Yes.
And request a directive as to service.
Well, I would be disinclined to grant any order. The re-enrollment following the removal on the 17th of March, doesn't appear to have been any further correspondence or any attempt to bring to the attention of the respondents that the matter would be finalized today. And the difficulty with the service simply compounds that. So in my view, it would be necessary to postpone the matter and that you would then re-enroll it upon notice of the date of re-enrollment, and at the same time try to perfect the service. And I would be inclined to authorize service at the work address as you've requested. Do you wish to remove the matter for re-enrollment on those terms, or do you wish to postpone it to a fixed date?
My lord, I think in the circumstances it would be prudent to remove the matter from the roll.
Yes. Yes. Well, I will simply then remove the matter from the roll, but further direct that service of the papers and service of the notice of set down be effected on the work address of the first respondent.
As the court pleases, my lord.
Matter number 9 on the roll, Bank Limited versus Philip Giorgio N.O.
Please the court, my lord, I appear for the applicant in this matter and following 8 matters, Mr. Lamprecht for the respondent.
Yes.
My lord noted that a substantive application for postponement has been served and filed by the respondent. My lord, might it be prudent that the matter be dealt with at the end of the roll?
Yes. Is it intended to argue the question of postponement at the end of the roll in all of these 8 matters.
It is indeed, my lord.
Yes, and I ask that only just to understand that the parties are not at this stage in agreement that the matter should be postponed.
I apologize, we had a connectivity issue there.
I beg your pardon. I ask simply to understand that the question of the postponement is to be argued, that the parties are not in agreement. I see. Yes, well then in this matter, from the matters 9 through to 16, they will stand down to the end of the roll for the question of argument to be addressed on the postponement that has been sought.
As a court, please.
Matter number 17 on the roll, Wool versus Wood.
May it please you, my lord, I appear on behalf of the applicant in this application involving a minor child.
Yes.
My lord, the application was originally set down on the uncontested opposed roll. The parties have agreed to mediate, and following, in the event of unsuccessful mediation, that the time periods would follow
Yes.
for the filing of an answering affidavit. There is a draft order that's been placed before my lord. The only item that I wish to add to the draft order is that this draft is by agreement between the parties. That's neglected in the draft before my lord, if I could.
Yes. Thank you. I have received the draft order. There will then be, by agreement between the parties, an order in terms of the draft which I have marked A. So, Ms. Rossi, did you hear that? Yes, we appear to have been interrupted. Can the parties hear me? You can just indicate by raising your hand. So those, yes, appears to have been a slight disruption in the connection. Ms. Rossi, I was simply indicating, and this is when the break occurred in the matter of Will versus Wood, that there will be an order by agreement between the parties in terms of the draft order which I've marked A.
As the court pleases, my lord.
Yes.
Matter number 18 on the roll, Burger versus Burger and 5 others.
It's the matter of Burger. Is there any appearance in the matter of Burger? Attorneys are Gravensteins and Skuman Oosthuizen. And a draft order was sent through to me today. Yes, well, I'll stand the matter down to the end of the roll at this stage. Perhaps council will join shortly.
Matter number 19 on the roll, the Nelson Mandela Bay Metropolitan Municipality versus Jamari Project CC Trading as Project Assist Group and others.
Please you, my lord, I appear for the applicant in this application to compel discussion. Lord, there was some correspondence suggesting that the second respondent, there might be an appearance for the second respondent relating to costs. I'm unfortunately unable to indicate to you whether there is such an appearance.
Yes. Yes, we are conducting these proceedings from motion court. The both security at the court and the registrar is aware of the fact that this is the protocol followed. So if there is any appearance by a party in person, then they would be brought through to the court.
Please, the court, my lord.
I
appear for the second respondent in this matter.
Yes. Yes. Well, there you have the answer.
Thank you, my Lord. Lord, what's happened is that the second respondent has, since the launch of the application, filed a discovery affidavit. There has been no response from the first and third respondents, and I respectfully suggest that a proper case has been made out for the relief sought, and in which regard I have forwarded a draft order to your registrar. With regard to the second respondent, I understand that the issue is purely a question of costs, which is provided for in the draft, but I don't know what the attitude of the second respondent in that regard is.
Yes, thank you, Mr. Richards. Mr. Lamprecht?
My Lord, just briefly in relation to the second respondent's position as to costs, my Lord would notice that this dispute flows from 2014, and this action was only instituted in 2017, and the request for discovery was made in 2019. My Lord, the second respondent's request is that costs should be stand over and to be determined by the judge hearing the trial in due course. So my Lord, no order should be made at this point.
So these are costs in relation to an application to compel discovery.
Indeed,
why should they stand over to the trial? In what way will the trial court be in a better position than this court to determine whether the second respondent would be liable for costs? Surely the key question is whether the second respondent filed a discovery affidavit after the application was launched.
My Lord, I would be constrained to concede that point. It's merely my instruction to submit that the trial court would be in a better position to make a determination as to costs.
Yes. Yes.
My Lord, I can't take further than that.
Yes, thank you. Sorry, Mr.
Lord, in brief response, I submit that it's apparent from the papers that not only was the original notice served in March 2019, there have been 2 subsequent reminder letters to which no response was received. And the only response to the application was then the filing of a discovery affidavit. And I respectfully submit that costs would or should follow. And I move for an order in terms of the draft.
Yes, thank you. Yes, anything further, Mr. Lamprecht, before I make the order?
I have nothing further to add.
Thank you.
My Lord.
Yes, thank you. There will be an order in terms of the draft order, which I have marked A, and just for clarity's sake, the draft order makes provision in paragraph 3 that the first, second, and third respondents jointly and severally pay the costs of the application.
As your Lordship pleases.
As God pleases.
Matter number 20 on the roll, Edmondson and another.
My Lord, I appear on behalf of the applicants. This is the application for the appointment of a curator ad litem to report on whether there's a necessity for the appointment of a curator bonus and curator persona. I've prepared a draft order that I believe was sent through to court this morning. I don't know if it's made its way to your Lordship's file yet.
Yes, Ms. Gagiana, I don't believe that it has. The order differ in any way from that which is set out in paragraphs 1 and 2 of the notice of motion.
My draft order, my Lord?
Yes.
Yes, my Lord. It's everything that I'm praying for in the draft order is obviously dealt with in the affidavit itself. I just thought it would be helpful to have an order that's a bit more comprehensive and gives the curator ad litem more specific instructions.
Yes.
Specifically insofar as the identity of the other 2 curators are concerned, but everything in there is provided for in the affidavit itself.
Yes.
As your Lordship knows, there will be no prejudice. There are no respondents. So I thought it would be an order to...
Well, perhaps what I would suggest that you could do, perhaps, is would you be in a position to email that draft order to to me or to my clerk during the course of the hearing, and the matter can stand down
Yes.
for that purpose. Yes, thank you.
As the court pleases.
Then I'll stand the matter down, and you can forward the draft order by email, and we'll deal with it.
As the court pleases, my lord.
Thank you.
Matter number 21 on the roll, McWilliams versus McWilliams and others.
May it please you, my lord.
Yes, thank you, Mr. Gadra.
I appear on behalf of the applicant in this matter. My lord, this is an application when the applicant seeks that the respondent replies to the Rule 35(3) notice, which was previously served by email to him. I'm not sure if my lord requires me to take my lord through the various email correspondences, or is my lord satisfied that the respondent in fact got notice. In fact, in amplification of that, I can perhaps just advise my lord, this morning, the respondent had filed by email a notice to oppose the taxation which has been set down against him by email. And it is in fact one of the email addresses to which the present application was transmitted.
Yes.
If my lord is otherwise satisfied, I'll move for an order in terms of the draft, which should be on my lord's file. And my lord, in that draft, you will note that there is the period within which the respondent is to file his reply is left blank, albeit that the applicant sought a period of 5 days. If my lord is satisfied that that period is adequate or sufficient, then I'd ask that my lord perhaps just insert that period or such other period that my lord would feel is adequate.
Yes, given the particular circumstances and the scale of the request, it may be that a longer period should be afforded to the first defendant, and I would be inclined to provide not for 5 days but for 15 days in the circumstances.
As the court pleases.
Yes.
I would then just ask for that to be inserted in the draft, my lord, and then move for an order in terms of the draft.
Yes, thank you. Yes, I will insert in paragraph 1 of the order that the reply be delivered by no later than 15 days after service of the order. And apart from that amendment, an order will then issue in terms of the draft order.
As the court pleases.
Matter number 22 on the roll, Heath, Elmarie Bonita Heath.
May it please the court, my lord, I appear on behalf of the applicant in this application for the appointment of a curator ad litem. My lord, I submit that a proper case has been made out, and I move for an order in terms of Part A of the Notice of Motion, paragraph 1, which is contained on page 1 and 2 of the papers.
Yes, thank you, Ms. Morgan. There'll be an order in terms of paragraph 1 in Part A of the Notice of Motion.
As the court pleases.
Matter number 23 on the roll, Standard Bank of South Africa Limited versus Footer and another.
Yes, is there an appearance in this matter, the matter of Footer, Standard Bank? Is there no appearance in the matter of Footer? Yes, this matter will be removed from the roll.
Matter number 24 on the roll, Standard Bank of South Africa Limited versus Pillay and another.
Is there any appearance in the matter of Standard Bank versus Pillay? The same firm of attorneys are involved in this matter as the previous matter. Is there any appearance in this matter? Matter is removed from the roll.
Matter number 25 on the roll, Standard Bank of South Africa Limited versus Brandems.
Yes. Is there any appearance in this matter? I think it's the same attorney's firm involved in the previous two matters. Yes, I might indicate for the record that Mr. Brunders, the respondent in this matter, has arrived at court and is present in court and has stepped up to the witness box. And but perhaps I could just indicate, Mr. Brunders, the plaintiff in this matter is represented by a firm of attorneys, as you would know, and it appears that there is no appearance for them today. I'm not sure why that is. I had some concerns in this matter about whether you had in fact received notice, but the fact that you are here suggests clearly you have. What I'm inclined to do is to simply remove the matter from the roll. There is no one here representing the plaintiff who would seek an order. And what the plaintiff would have to do is to re-enroll the matter and to do so on notice to you in due course. And on that occasion, you would then be in a position to address the court hearing the matter as to how it is that you want this matter dealt with. All right. I would thank you for taking the trouble to come to court. So this matter is simply removed from the roll.
Matter number 26 on the roll, the National Director of Public Prosecutions.
As the court pleases, my lord, I confirm my appearance on behalf of the applicant in this matter.
Yes,
being a application brought in terms of Section 38 of the Prevention of Organised Crime Act. My lord, yes. I submit that a proper case has been made out on the papers, and if your lordship is so inclined, might I move for an order in terms of the draft reservation appearing at pages 3 to 10 of the papers?
Yes, thank you, Mr. Myberg. There will be an order in terms of the draft preservation order, which appears at pages 3 to 10 of the papers.
Matter number 27 on the roll, 983 of 2020, the National Director of Public Prosecutions.
As the court pleases, my lord, I'll confirm my appearance on behalf of the applicant in this matter. It's a similar matter as to the previous one called. My lord, I submit that a proper case has been made out, and if your lordship is made inclined to grant an order, might I move for an order in terms of the draft preservation order on pages 3 to 10 of the papers?
Thank you, Mr. Myberg. I am so satisfied. There will be an order in terms of the draft preservation order, which appears at pages 3 to 10 of the papers.
Let's go, please, my lord.
Matter number 28 on the roll, 775 of 2020, National Director of Public Prosecutions.
Yes.
As good, please, my lord, I confirm my appearance on behalf of the applicant in this matter. This is a slightly different matter. It's an application at forfeiture and brought in terms of Section 48(1), Regular Section 53 of the Prevention of Organised Crime Act. My lord, I submit that a proper case has been made out on the papers, and if your lordship is so inclined, might I move for an order in terms of the draft forfeiture order appearing more fully at page 3 of the papers.
Yes, yes, Mr. Myberg, in this matter, unfortunately, I'm not so satisfied. For the following reasons. The preservation order was served on the 24th of March of this year, and publication occurred on the 27th of March.
Yes,
in terms of the time period provided for in the preservation order, that time period would have extended beyond the period affected by the initial lockdown, which occurred on the 31st of March. So that just a few days after the service of the order, the respondent would not have been in a position either to access legal services or to file any process at court. And for that reason, I would be inclined to postpone the matter and direct that there be a service of the forfeiture application on the respondent. I'm aware of the fact that one can deal with these matters effectively ex parte, and that the Act makes robust provision for that. But in these circumstances, I wouldn't be satisfied and I wouldn't grant such an order.
My Lord, in the circumstances, might this matter be postponed for a period of 4 weeks?
Yes. And the date is the
23rd of June, my Lord.
The 23rd of June.
Yes, my Lord. And the applicant undertakes, as per your directive, to serve the forfeiture application on the on Mr. Norbebe as well.
Yes. Yes, thank you, Mr. Myberg. This matter then will be postponed to the 23rd of June, 2020.
As a court, please, my Lord.
Matter number 29 on the roll, Hagedorn Hansen versus Hagedorn Hansen.
May it please you, my Lord, I appear on behalf of the applicant in this matter. This is an unopposed application for the joinder of the second to the 8th respondent to the pending trial in this matter. My Lord, the papers were extensive, short heads were filed. Your Lordship would have noted that relief was sought in terms of the draft order annexed to the papers. I am advised by my attorney that a new draft order was sent to Your Lordship's clerk this morning. There's no difference between the two orders other than the name of the sitting judge. Furthermore, my Lord, you will also have received, or your clerk would have received, a notification from the second respondent that he doesn't intend opposing the application either.
Yes, I did see that.
Yes. Then, my Lord, in the circumstances, I submit that a proper case has been made out and that Your Lordship will grant the order sought in the draft order.
Thank you. I just wish to find the draft order that you referred
Lord,
to.
if you just bear with me a second, the new one or the old one?
No, the old one, and we didn't receive the new one, but
it will be in your clerk's mail. My Lord, you will find it in the papers at page, there we go, I've got the page number. It is page 18.
Yes, thank you. Page 180.
189.
Beg your pardon. Thank you. Yes, well then, in this matter, there will be an order in terms of paragraphs 1, 2, and 3 of the draft order pages at page 189 of the papers.
As Your Lordship pleases.
Matter number 30 on the roll, First Rand Bank Limited versus Vasi.
As it pleases the court, my lord, I appear for the applicant in this matter. This is a matter in which the mechanic is for a default judgment. However, the relief sought at this stage is for an order in terms of section 130 of the National Credit Act for a directive specifying a new service address, in this instance via email. I believe there is a draft order attached to my lord's papers at pages 47 and 48. And if my lord is inclined, I'd move for an order in terms of the attached draft.
Yes, thank you. There will be an order in terms of the draft order, which appears at pages 47 to 48 of the papers.
As the court pleases, my lord.
Matter number 31 on the roll, First Rand Bank Limited versus Mbukyu.
Mr. Court, my lord, I appear for the applicant in this matter, similar to that of the matter previously called, in which an order in terms of 130 is also sought. The draft is again at pages 47 and 48 of my lord's bundle.
Yes. Yes, thank you, Mr. White. There will be an order in terms of the draft order at pages 47 to 48 of the papers.
As the court pleases, my lord.
Matter number 32 on the roll, the Nieuwenhuizen versus the Road Accident Fund.
May it please the court, my lord, I appear on behalf of the applicant in this application for the appointment of a curator ad litem, and I submit that the papers are in order. And if the court is satisfied, I would move for an order in terms of prayers 1 and 2 of the notice of motion.
Yes, just give me one moment, please.
As the court pleases.
Sorry, the papers are quite voluminous. We have to, I'm just, yes, there'll be an order in terms of prayers 1 and 2 of the notice of motion.
As the court pleases.
Matter number 33 on the roll, Sewu versus the Road Accident Fund.
May it please you, my lord, I appear on behalf of the applicant in this matter.
Thank you, Ms. Barnard.
My lord, this is an application for the appointment of a curator bonus. I will submit that a proper case has been made out and the curator ad litem is also present should his lordship have any further questions. I have sent through a draft order this morning. Has your lordship had an opportunity to have regard to say?
Yes. Yes, I have. Thank
my
you.
lord, the only manner in which the draft order differs from the notice of set down is paragraph 5 and 6, which includes the specific requests of the master, being to refer the curator bonus to certain regulations and sections and in respect of his remuneration.
Yes.
I do need to move for one minor amendment, my lord. If I might refer to paragraph 3, it refers to the curator bonus as bijna to Priya. That should be more than Strubich. If the draft might just be amended.
Yes.
Yes,
paragraph 3 is amended to insert the name Morne Strivich.
As the court pleases. I then move for an order in terms of the amended draft, my lord.
Yes, thank you. Yes, I will mark the draft as A, and there will be an order in terms of the draft marked A.
As the court pleases.
Matter number 34 on the roll, K2013162303, trading as Rehab Schools Pty Limited.
I confirm my appearance on behalf of the applicant in this matter, my lord. My lord, I submit that a proper case has been made out. This matter was previously not enrolled, and I have prepared a draft order. I trust that it has made its way to your lordship's file.
It has, thank you, Mr. Clark.
If you're satisfied, my lord, I would move for an order in terms of the draft with one amendment, the deletion of the S on applicants. And other than that, I submit that the draft order accords with the notice of motion, and I would ask for an order in terms of the draft suitably amended.
Yes. Yes, thank you. Thank you. There will be an order in terms of the draft, which I have marked A.
As the court pleases.
Matter number 35 on the roll, Rehab Discount CC.
My lord, this is a similar matter. I had a connectivity problem there. Is that Rehab Discount CC?
Yes.
My lord, I confirm my appearance on behalf of the applicant of this matter as well. This is a similar matter.
Yes.
I again submit that a proper case has been made out, my lord. This was also a matter that was not previously, or for some other reason, didn't find its way onto the roll. There's also a draft order, and I would ask for a similar amendment by the deletion of the S on applicants.
Yes.
Failing which, my lord, if you are satisfied, I would ask for an order in terms of the draft.
Yes. There will be an order in terms of the draft, which I again will mark A.
as the court pleases.
Matter number 20 on roll, Edmondson.
Yes, this is the matter of
My Lord,
Edmonds.
yes, my Lord. Have you received the draft order yet? I've received confirmation from.
Scagiano, are you there? It's a bit broken down.
Can you hear me now, my Lord?
Yes, I'm hoping so. We had a break. Did we have a similar mishap previously, Ms. Scagiano, or was it not when you were dealing with the matter?
That wasn't me. That's
Not
my
you.
Lord. My Lord, have you received the draft order?
If you would just give me one moment. Yes, well, and you sent it directly to my email address?
No, my Lord, it was sent.
No. Are we there? Bandwidth. I think that's the problem.
Do you want to record these Gold Bank matters next?
Yes, thank you, Ms. Scagiano. Yes, I apologize. We appear to have had another minor interruption, but I have received the draft order. So that is, and so I assume that you move for a draft order in this matter of Edmondson.
Yes, that's correct, my Lord.
Yes, thank you. Then there will be an order in terms of the draft, and as is my wont, I shall mark it A.
As the court pleases.
Yes, thank you.
Matter number 18 on the roll, Burger versus Burger.
As the court pleases, my Lord, Paul de Tooy appearing on behalf of the applicant.
Yes.
I had a connectivity problem previously, my Lord.
I understand. Yes.
Okay, I apologize for that. My Lord, an order was sent through to you this morning. I hope that you received it.
Yes.
I submitted the papers are in order, and if you are so inclined, I ask for an order in terms of the draft. Your Lordship would have noticed that I kept the date open in paragraph 1 thereof.
Yes.
It is a substantial amount of documents that we're asking from a person in a different area, courts area. So if your Lordship, with your discretion, can give us a date that you would deem suitable.
Yes. Are you wanting a fixed date rather than a number of days, as I
think, then there won't be any fights about the interpretation of the court's order, my Lord.
Yes.
On matter number 21, you gave 3 weeks. 3 weeks is the 16th. So might I suggest that your Lordship do the same here, but then set the date of the 17th of June.
Yes. Yes, I will do that. I will then insert the date of the 17th of June, 2020 in paragraph 1 of the draft order that you have supplied, and there will be an order in terms of that draft order.
As the court pleases, my Lord.
Matters number 9 to 16, Growbank versus Giorgio N.O. and others.
Please, the court, my lord. This is the matters that stood down for the application for postponement.
Yes.
Well, let's see. There are still other
Yes,
participants.
there are other counsel in there. Are there any other matters that have stood down? Yes. Yes, the matter of 6, the matter of De Jong. I don't see the counsel who were involved in that matter before me. I don't know. Mr. Palmer, sorry.
Yes, good morning, my lord.
draft order has been prepared by the curator ad litem.
Yes.
And the contents of same are acceptable to my client and to us. And we ask that an order be granted. Maybe if Advocate Bands could just explain the content of the order. It's a very short order if acceptable to you, my lord.
Yes. Yes, thank you, Mr. Palmer. Mr. Bands?
My lord, it has been sent through to your clerk.
Yes.
I don't know your only email address I've got for you is your Gmail address. I'm not sure if that is the correct one to send to you.
No, I think what we will do is my clerk will just check the email, her email quickly, and so we'll just stand it down, and I'll deal with the other argument briefly before that, Mr. Bands and Mr. Palmer, and then thereafter, once I have the order, I can check it and make such order if that suits you. So we'll just stand this matter down for a few more minutes.
Thank you, my lord.
Yes, we'll then call the matters of Growbank Limited. There are is it 8 of them, 6 of them, and I think Mr. Williams, you appeared in the.
I do indeed, my lord. My lord, the first matter is matter number 628 of 2020. My lord, as I've indicated, an application for postponement has been filed. The basis of the application, all 8 matters, is predominantly the same. I would suggest, my lord, that the result in the outcome of the application for postponement in matter number 628 would then be the result that follows in the remaining matters.
Yes.
Under those circumstances, my lord, perhaps Mr. Lamprecht could address you first. My lord, an opposing affidavit I've been provided with an opposing affidavit by Growbank. Might I inquire as to whether that has made its way into the court file? It's an affidavit proposed to by Mr. Smith.
Yes.
And because it was served on 22 May, my lord.
Yes, I don't believe that I have received any opposing affidavit. I have in each of these matters, as you correctly indicate, the basis upon which the postponement is sought is really the same. But I've not received any opposing papers. Sorry, Mr. Williams, we had a brief break in the transmission. I was indicating to you that I have not, in fact, received any opposing papers or opposing affidavits filed in these Growbank Limited matters.
My lord, I was trying to think of the most convenient way to deal with them. It's effectively a 4-page affidavit dealing very briefly with the applications. My lord, might I inquire whether I could email it through to your clerk, yes, and if then stand down to afford you an opportunity to peruse it. My lord, again, it's only necessary, David, the same opposition is filed in the remaining applications.
Yes, indeed. Yes, I think, perhaps I could just ask Mr. Lamprecht, would your client wish in any way, you presumably have seen the opposing affidavit, your client wish to file any reply in relation to that opposing affidavit?
My lord, at this point, no. It's a very generic, bare opposition to the application, my lord, so it should be right for argument.
Yes. All right, well then, thank you. Then I would ask Mr. Williams if you would send the short affidavit through to my clerk by email, and then we will stand the matter down so that I could obtain that and consider it before you address me. So we'll stand the matter down for a short while so that you can send that through.
Yeah.
Thank you. Sorry, Mr. Baster.
My lord, I have a watching brief in this matter. I would appreciate if you could give argument for a postponement because I appeared in a matter where we obtained an order against ART Holdings and Growbank during November of last year. So I have a watching brief in this matter, and I would just appreciate being included should you commence these proceedings again.
Certainly. Thank you, Mr. Bester. We certainly will. And are you in receipt of the papers in the opposing?
No, my lord. My brief is purely a watching brief. I saw the matter on the roll, got hold of client because we have commenced contempt of court proceedings based on our order of November of last year.
Yes, and you received. Sorry, your order was obtained against.
Against a company known as ART Holdings International Pty Limited under case number 2588 for the delivery of the vehicle that was sold. And we subsequently established that this vehicle is financed at Growbank through another trust. And Growbank appears to have launched these proceedings to inter alia take possession of my client's vehicle, which he's had for more than a year.
I see.
Therefore, we have a watching brief to determine what the outcome of the proceedings are.
Thank you, Mr. Bester. Yes, well then this matter will simply stand down so that the affidavit may be sent to me by email, and we can take it from there shortly. Yes,
My lord, is it at all possible that we could agree on a time for the recommencement of the hearing?
Yes, I think that's perhaps what I will do is yes, I think we will. I'll finish the motion court, and I will then convene a separate hearing, and the parties will be notified of the login details for that hearing for purposes of argument. If I could simply ask Mr. Williams if you would just make sure in your email to my clerk that the email addresses of all of the parties, including Mr. Best, are included in that so that we can communicate the login details. And then I would suggest that we would reconvene at 11 o'clock this morning.
As a court, please, my lord.
Court, please.
Yes.
As please, my lord.
Yes, thank you. Well, then we can deal now. Let us deal with the De Jong matter. Mr. Palmer and Mr. Bands, I have received the draft order. It has been emailed through to me. And
in essence, my lord, if I could assist you, one of the affidavits that was attached to the papers was by Dr. Heather Rauch.
Yes.
She's a social worker, and she's recommended that we appoint somebody to assist the parties, and the first respondent will be moving to Sedgefield, which is convenient because both my client and the first respondents will be in close proximity to each other. She's recommending the appointment of Linda Lifson, who will then assist the parties to manage the various issues that are provided for in the court order. So we're fully in support of this approach to this matter, my lord. Maybe if Advocate Bands could also come in here, if there's anything that he wants to add to this.
Thank you, Mr. Palmer. Mr. Bands?
No, my lord, just to state that we are obviously also in support of the order.
Yes. Yes. Thank you. Then in these circumstances, I would make an order in terms of the draft order which has been furnished to me. I will mark it A and place it on the court file.
As the court pleases.
As the court pleases, may I be excused, my lord?
Yes, you may. Thank you, Mr. Palmer.
Last day.
Yes, Mr. De Beer, I see that Mr. De Beer is out. It's gone. Thank you.
Is there something you wanted to ask Mr. De Beer, my
No,
lord?
no. I was just wanting to make sure that he didn't have another matter before me. Thank you.
He is my correspondent, my lord,
I
in this
understand.
matter. So, okay. Thank you very much.
Thank you.
Okay.
Thank you.
Thank you, my lord.
Yes. Well, then, motion court will stand adjourned.